Lawyers, please stop in advising your client that after a number of years they can get their masters back from the record label. The Nigerian Copyright Act does not recognize it. Hello guys, my name is Jeanette and I'm back again with another controversial. You all know I'm an entertainment lawyer, I'm a music publisher. In this my small talks, I discuss entertainment law, music business, music publishing, music distribution, and today I'm going to be talking about a controversial take. So you know when an artist comes online, comes on Twitter, comes on Instagram to call out a record label boss, their former record label that they cheated them, they own their masters, and so many people go on LinkedIn and put some posts about how it's very important for artists and creatives to get lawyers when they're about to sign a deal, and also the agreement must contain a right revision clause which says that maybe after the term of the record deal or after a number of years, the master's rights can return to the artist. Well, what these people saying are valid, but under the Nigerian Copyright Act, it doesn't hold any water. Because according to section 108 of the Nigerian Copyright Act, it says that the author of a sound recording is a person by whom the arrangement of the works was created. So if a music company signs an artist and they dropped money for recording budget, they paid beats, they paid for the beats, they paid the producer, they paid for the artwork, they paid for the advanced sum of money for the recording budget of the project, the Nigerian Copyright Act recognizes them as the author and first ownership of the sound recording, and that is what people need to understand. In my opinion, the lawyers who are saying this or the music executives who are saying this are actually correct, but as a lawyer you need to understand that if you are putting a right to revision clause in your music record deal agreement, and in the same breath you inserted another clause that the terms of the agreement will be subject to the laws of the federal government of Nigeria, so that means that right to revision clause in the agreement is already working against the intent of the agreement, if you understand what I mean. So you are saying that okay, a right to revision clause should be in the music recording. At the same time, they are inserting a regulation that says that does not recognize the right to revision clause. So that means that the right to revision clause is inserted into that agreement does not hold any water and will not take effect on the record label. So you need to be very careful when you are inserting this kind of sentimental clauses in the agreement. And so you guys can say, oh, Daniel did this, G Worldwide, he got his masters back from G Worldwide, Burna Boy did it, he got his masters back from Aristocrat Records. You need to understand that the new Nigerian Copyright Act was created in 2022 and came into law in 2023. So Daniel and Burna Boy, they signed their contracts under the former Nigerian Copyright Act. So their master's ownership is still subject to the previous Nigerian Copyright Act, not the new Nigerian Copyright Act. So that is why they can always get reassigned their music rights. And you also like to bring to your notice that under the previous Nigerian Copyright Act, it says that the authorship of the sound recording vests in the artist in whose name the records was made, except there is an express agreement that states otherwise. So in the case of Daniel and G Worldwide, Burna Boy and Aristocrats, even though the Nigerian Copyright Act says that they own the sound recording or they are the author of the sound recording, but they would have entered written agreement with Aristocrats and G Worldwide respectively, saying that the transfer of master's rights should be from Daniel, Burna Boy to G Worldwide, Aristocrat Records. So that transfer of master's rights to this company was made possible by an express agreement, aka a signed agreement. So now, after some years, these two artists went back to their record label and decided to get their masters back. So that's a reassignment or a transfer of the masters right back from these companies to these artists, because the former or the previous Nigerian Copyright Act made it possible for it to be so. You need to understand all these things. But that new Nigerian Copyright Act is pretty much straightforward. If you paid for the records, if you paid for the masters, you own the masters, period. And if any artist is trying to get their masters back, they have to buy the masters back, or they have to get an assignment of the masters back to, they have to get an assignment of the masters to the artist, not back to the artist, because there was no reassignment in place under the Nigerian Copyright Act. So the crux of the matter is now, guys, come down with the right revision clauses or the right revision requirements. The Nigerian Copyright Act does not recognize it. Lawyers, please stop in advising your client that that after a number of years they can get their masters back from the record label. The Nigerian Copyright Act does not recognize it. It's pretty much straightforward that he who pays for the masters will own the masters. He who pays for an advance of recording budget owns the master. There's nothing like they are getting back. You an artist, you can get back your masters. Even if you cannot exactly get your masters back, you can only buy your masters and all of that. And for record labels, this is not an opportunity for you to say, because the law says I own the masters, so I can do anything with it. Apart from paying for the ownership of the masters, you have to be sure that you have the right to exploit the artist performance rights. So you have to be an agreement in place that says that even though we own the right to the masters, we also need permission or a license to exploit the performance right, so we can release these masters and make money from it. This is why it's advisable for you, an artist, or for you, a record label, to get a music lawyer or an entertainment lawyer who is proficient in this and who is well knowledgeable in this, because I'm very sure that most music lawyers are not even aware of this fact, even though it is in fine writing or fine printing in the Nigerian Copyright. So I'm using this opportunity to introduce my music law training program for young lawyers, for court aspirants, for law undergraduates who want to understand music copyright, what the law says about the rights of creatives, how to represent your artist clients, your producer clients, and all of that. So if you don't understand all these things, if you don't have the required knowledge or expertise, how exactly do you want to help your artists or help your label clients or your company clients to make good decisions that will protect them in future? So if you want to know more about this class, kindly click the link on this post or send me a DM for more information. I hope you guys are getting something new today. Kindly share and comment and make everybody aware of this. I can't wait to see you guys in my next class. Bye guys. Sorry, next video. Bye guys.